from a man who boldly opts for jail time over probation.
That is the case. He is asking for a payment plan as to fines and costs. However, he is respectfully requesting that the court consider sentencing him to the time instead of probation.
To a woman charged with aiding a felon.
And you understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
These cases unveil the stark realities of the criminal justice system in action. Starting with Judge Simpson presiding over Mr. Brent's case, here's a man who shocks everyone by boldly requesting jail time over probation, leaving you wondering about his state of mind. What's even more unbelievable is his claim that jail is easier than following probation requirements. And to top it all off, he's a father. You won't want to miss this.
First case, People versus Guy Brent.
Special Lobby for People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Brent, who stands to my right. Please state your name for the record, sir.
Guy Brent.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review the PSIR as well as the recommendation from probation. As to the report, we have no material changes or corrections, but my client does ask that I make a brief request as to the recommendation.
All right.
To be candid, Mr. Brent does understand that the court will likely be following the recommendation and sentencing him to probation. That is the case. He is asking for a payment plan as to fines and costs. However, he is respectfully requesting that the court consider sentencing him to the time instead of probation. He does understand that he will likely be
Wants to go to jail for a year.
That is the request you asked that I make today, Your Honor. He is willing to comply with probation if need be. However, given the expenses and some of the obligations, he is asking to serve the time instead. He understands, though, that Your Honor will likely adopt the recommendation.
You want to go to jail?
No, sir. It was dealing with probation.
So you think it'd just be easier if I just sent you to jail?
Well, just the way this probation is just a lot right now. I'm gonna try to complete it, but I got 6-week program for program or whatnot.
You're doing a substance abuse program right now? So if I send you to jail, what happens to your participation in that program?
I'm not sure. I actually didn't follow up with that. I just talked to her this morning. I didn't talk to
Your Honor, if I may, I believe he would not be allowed to continue with that program, unfortunately. And I did encourage him to stick with that program and under the supervision of probation.
Tracy Clare on behalf of probation. Your Honor, with that program that he's speaking of, he is in CCOP. As a condition of bond, he had to be drug testing. He had some issues with the testing and I think conversation with the agent over there. Given the conversations that they had, they referred him to CCOP, which he has completed the intake and the ANAC program. That's why it is picked up and adopted with the recommendation to the court.
Thank you.
That is all correct, Your Honor.
I'm still trying to figure out why you want me to send you to jail for a year.
I was unclear that it was a year, but I also have another.
So even if it were 93 days, why would you want me to do that?
Because I have another case on the 11th, and I believe I think they're putting me on probation for that as well. And so I'm getting a probation. I guess I have 2 probation officers, Cheryl Boyke and Teresa. And that's a lot to keep up with.
Your Honor, he has sentencing at 14B on December 11th. And that is for a failed to report an accident.
You're working.
Probation.
You're in a treatment program, right? Try to deal with some of your issues. Where are you living? You by yourself?
Yes, sir.
You rent? How long you been in that apartment or that place?
My whole life, 26
Pardon?
years. My whole life, 26 years.
In that residence?
Yes, sir.
Is that somebody else's house or yours?
My mom's here.
How old are you?
27 today.
What would your mother say if she knew that you were up here asking me to send you to jail?
Whatever the.
What would your mother tell? What would your mother say?
Whatever, just to get me over with this as soon as possible. Both cases.
So you understand that if I accede to your wishes and send you to jail, then on the 11th, Judge Washington might still put you on probation of some type.
I believe that was just dismissed, and I was just showing up for
You're 7%.
Yeah, that's
dismissed.
I mean, sentencing was just to follow up with, because I reimbursed the victim, so I understand I pled no contest, but from my understanding, the judge that was sentencing me was understood, guess talked to my attorney and understood that I reimbursed the victim. And of course, I couldn't get it dismissed because I pled no contest, but, you know, I guess I can't say it's going to get dismissed because I played no contest, but I doubt if I get probation for that one.
So you don't think you can do this probation?
I can't. It's just.
What?
I can't.
Then why do you want me to send you to jail if you know you can?
I guess I'll just withdraw the request.
Your Honor, if I may briefly, we would like to withdraw that request. And I do believe that this recommendation from probation is a good recommendation. And I do also believe that Mr. Brent will follow it and benefit from it. And I do believe that he'll remain in compliance. I know he is a hard worker. He works full-time, 7 to 3 shift at Taco Bell, full-time, been there for a while. And I believe your child is 7 years old and he just does support a 7-year-old child. I believe he will.
You've got to be kidding. You have a child?
Yes, sir.
How often do you see your child?
About 4 days a week.
How many?
About 4 days a week.
Girl or boy?
Boy.
So what's that child think when all of a sudden I don't see daddy at all?
Well, I don't want to get into details of the case, but during the incident of the situation, he was on scene. And like I said, I was just...
No. That's not what I'm talking about.
Yeah.
You see him 3-4 times a week, right? So if I send you to jail, how many times are you going to see him a week? So why would you do that to him?
He witnessed me get taken to jail the day of this incident. Like I said, I was just wrong place, wrong time that day. And I was unaware I had warrants out, so they had to take me to jail. Yeah. So it's not like he hasn't, dealt with it before. It's just...
Young man, do you understand what I'm asking you? How do you do that to your son? Don't care what he witnessed. How do you do that to your son to just disappear for a year? And worst of all, ask me to do it.
I was unaware that it was a year. I understood I had since in February 3rd.
Okay, so let's say it's 93 days. It's not, but let's say that it's 93 days. Why would you do that to your son? You have an answer for me?
I don't.
Pretty stupid, isn't it? I mean, I'll just be blunt about it. It's stupid. I mean, aren't you out there trying to teach him the right way to do things?
Yes, sir.
Then if you're not there, how are you going to teach him? I'm going to just say this, and maybe I shouldn't say it, but I'm just going to say it anyway. I do not understand how somebody that looks like me comes up here and asks the court to send me to jail.
I've never dealt with probation before. It just became a hassle just due to the prior 3 weeks I've been on it. I mean, I'm compliant, and everything's been running smooth so far, but I dealing with my work schedule. And
Young man, tell you what I want to do? I want to send you to school and make you take a history lesson. Because if you took one, maybe knew a little bit more about your history, there would be no way you would come up in any courtroom and ask to be sent to jail. Anything else?
Brunch.
Yes.
Thanks.
Because they're going to bring up. Yeah, anyway. All right, we're back on the record in the case of the people versus Guy Brent. Mr. Brent, let me try to understand your living circumstances. Okay, if I can. Who do you reside on you reside on Jefferson Street?
yes, sir.
Who lives there with you?
I stay by myself.
Pardon?
I stay by myself.
Okay, where's your mother live?
She lives in Detroit, Michigan. She just moved out there December 2023.
So how long has she been out there?
December 2023.
Okay. So how are you seeing your son?
I pick him up from school.
If I may, Your Honor, Mr. Brent, have you been doing that since October 25th or is this prior?
I haven't seen him since this case, October 25th. I haven't seen him not one time since October 25th.
Hold on. I asked you how often you see your son.
Prior to the case, for about 4 to 5.
Well, you didn't say that to me.
Oh, I thought that's what you were asking. Because I was ordered not to, do not contact. So I can't see him. I can't call him. Nothing for this case.
How often do you go out to your mother's?
I just went for Thanksgiving. Prior to that, I only been out there probably twice.
So you've had no contact with the child?
And his mom as well.
Pardon?
His mom as well.
What city does the child live in?
He stays in Ypsilanti on Gulf side.
Tell you what I'm going to do. I'm going to adjourn his sentencing to the 16th because some of what's being told to me doesn't make any sense. And I'll explain some of it afterwards. And Ms. Polera, I may need you to look into something else.
Can I help you clarify?
I don't think you can.
Oh. Trying to figure out my living situation?
Well, maybe this. How often does your mother see your son?
Now since this case, a little more often. Used to be probably once a week. Now it's probably 3-4 times a week. She's filling my shoes. So
What I'm going to do is I'm going to adjourn the sentencing to December 16th, 2024, 1 p.m. And then we can talk about what I need to check into, Ms. Blair. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Richard Smith III.
Shalom for the people.
Oh, sorry, Your Honor. Assistant Public Defender Natalie Pay on behalf of Mr. Smith, whose appearance has been waived.
Teresa Polera on behalf of Probation. Your Honor, Mr. Smith is scheduled before.
Hold on a second. Hold on a second. Who's that with him? Yes. His grandmother, not his mother. Your grandmother lives here? Okay, we'll figure it out. Thank you.
Can I go?
Huh? Oh, yeah, you're, what'd you say? No, you're good. I was just I'm trying to figure out the dynamics of everything. And then I saw you and I was trying to figure out who you were, ma'am. Take care.
As to Richard Smith, Mr. Smith is scheduled before the court for review. It is the final review hearing in all 3 of those cases. Mr. Smith has fortnight waive in all 3 cases. That Mr. Smith be discharged from probation and his case is closed. No objection.
So ordered on all cases. That was so. Court recalls the case. People of the state of Michigan versus Isom.
Absolutely.
Kyle Riddle for Mr. Isom. Please state your name for the record.
Herbert L. Isom. All right, go ahead.
Your Honor, I believe we are requesting permission to approach.
Yes.
Our chair there.
While Mr. Brent was given a second chance to turn his life around, we have Mr. Lysom, who blatantly violated a no-contact order just days after it was issued. His sheer audacity makes you wonder if someone like this could ever take the law seriously.
Thank you, Emily. Just for everything. You're the joy in my day. Okay, not. Court does call the case. People versus Herbert Isom.
Kyle Riddle on behalf of Mr. Isom, who is approaching the podium and will be standing to my right. Mr. Isom, once you get up here, please introduce yourself to the court.
Herbert L. Isom. Thank you, sir.
Your Honor, today is the date and time set for pretrial. We are asking for an adjourned pretrial date. We understand that December 16th is the date that the court's giving.
Well, I will give you a date.
Okay.
How much time do you need?
I just was appointed, whatever the next available date is.
I'm not giving him that because he asked.
I was given by the staff, Your Honor.
Why are you giving up, Dave? Okay, all that stuff
I asked.
about what you do. Nah. No, don't give me the hand. All right. Miss Londa, you have arisen?
The people would like to address following of the court's ready.
Yes. I'll adjourn the matter to December 16th, 2024, 1 p.m. Yes, Esteban.
And our court is where this is a domestic violence case. In this case, the victim of the domestic violence incident was present in the courtroom. She informed me that the defendant sat down next to her in the courtroom when he came in. They were sitting together. My victim advocate did see that. They were separated when Mr. Lindell took the defendant out and told me to speak to him. And at that time, I know the victim advocate went and spoke with the victim. For the record, this is not a crowded courtroom. There are many, many open seats available. There is a no contact order that was entered on November 25th, 2024. It's now December 2nd, so just a few days ago, where the defendant wants to have absolutely no contact with the victim. People would contend that sitting next to her is contact. I understand she is here to address the court to request a removal of the no contact order. I have other information about that to share with the court whenever the court's ready, but she hasn't made that request yet, so it may be premature for me to respond to it. But I'm very concerned by him sitting down next to her when he's supposed to have absolutely no contact with her.
Response.
Yes, Your Honor. It is true. I spoke with Mr. Isom and as well as the complainant this morning. It is my understanding that we will be making a request to lift the no contact order and the no go-to order. Mr. Isom tells me that he has had no other contact. He has been abiding by the no contact order except for in the court this morning. And it's my understanding that.
Where does he reside?
Where do you live at the moment?
My brother's.
Okay, go ahead, Mr.
And Your Honor, we are requesting that the no contact order be converted to a no non-consensual contact order, as well as a no go-to order be lifted. It's my understanding that the complainant needs help around the house with both for herself as well as for their 4 dogs. And so we are just requesting that I did talk to my client about what the no contact order means, and that at the meantime, he should not be having contact until the court agrees. After we spoke, I instructed him to separate himself and sit on the other side of the courtroom, which he had no issue doing. So no matter what the court orders today, I'm confident that Mr. Isom will abide by whatever the order is, but we are requesting that.
Well, did he understand there was a no contact order in place?
Yes, I understood it, but I didn't know that in the court, that would be the same thing. I thought with the people here that
Why would it change?
I'm stupid. All I can say, ignorance.
What street are you staying on right now?
I'm staying in an apartment with my brother. It's right off of Michigan, or what's the name of the road? I don't even know the name of it.
Is it in Ypsilanti?
It's in Belleville. Green Tree or right off of 94.
Well, I'm going to tell you at this time, sir, and the best I can explain this to you, because I've had this other same incident occur just last week. I take the no contact orders very seriously. And when the court says no contact, that means no contact.
I understand.
Ms. Lundy, you want to say something else?
Your Honor, I just will let the court know as well. I heard the defendant say a second ago that he was staying off of Michigan. I would note for the record that the address shared with the victim was also off of Michigan Ave. So I hope that he is being truthful when he says that that's also where his brother is. We did request a $25,000 surety bond. He was given a $5,000 PR bond, no electronic monitoring. And the defense has moved to change the no contact to no non-consensual contact. I know the court historically has liked to hear from the victim, and if the court intends to follow that procedure, I'm happy to place my concerns about that on the record after we hear from her, or I can do it now. Whatever.
No, I can hear from you afterwards.
Okay.
Okay, where is she? Come on, sir, have a seat over here. Hello.
Good afternoon, Your Honor. My name is Donna Dennison, and I truly understand about the no contact, and I truly apologize. When he came into the court, I just scooted over so he could sit next to me. I didn't, like he said, ignorance. And I understand and I respect the court, and I duly greatly apologize. But me and the babies, we do need him to come home. He is our only care provider who takes me to my doctor's appointments.
Well, and I'll let you go on and tell me everything you want, but let me just tell you this.
I'm so sorry, Your Honor.
No, but ma'am, understand it's not your responsibility. It just isn't. It's his responsibility. Plain, just full stop. All right. You could have scooted it over and give him all kinds of room. It wouldn't matter. he understands or should understand what the court's order is. Okay, so anything else you want to tell me?
I would just please ask the court if they could let him please come home. We truly need him there.
All right, thank you.
Thank you, Your Honor.
Ms. Lundy.
Your Honor, in late 2023, the defendant was charged with domestic violence by my office, naming Ms. Denison as a victim at that time. I believe he was arraigned on December 26, 2023, and given a contact order. At a pretrial hearing before this court, Your Honor, on January 8, 2024, Ms. Denison appeared, requested the no contact order be lifted. That case was ultimately dismissed at the time of the final settlement conference in February of 2024. And we're back here again, new allegations of domestic violence. I'm very concerned for the victim's safety. I'm concerned that the obligation of the no contact order she feels on her. Obviously, we can't control how she feels and how she thinks, but the court is familiar with domestic violence situations, domestic violence relationships, and the shifting of responsibility that put on the victim. I'm asking the court to maintain the no contact order.
What was the never mind. All right. Go ahead, sir.
No, I was just anticipating what the court was going to, I thought I was anticipating what the court was going to ask. I just would add that the allegation in the police report is that this is a single shove onto a couch, is the allegation of the domestic violence. So the underlying crime that is alleged is fairly minor as far as in terms of the range of domestic violence cases that this court sees. And so I think that should be taken into consideration as well.
Well, but counsel, there's also an allegation of destruction of her property. Right? So it's that being the count 2 on the complaint. So it's not maybe as simplistic as one wants to believe. I guess I'm also a bit concerned with this previous. Yeah, well, I'm concerned about a number of things. I'm concerned about the fact that we had the previous case. I'm also concerned that there's a no contact order in place. And it's just these at this just ignore it. I mean, and it doesn't work that way. I mean, the cold-hearted reality is maybe you ought to tell me why I shouldn't incarcerate the defendant. I don't know that I could trust him.
Your Honor, I mean, I think, given the nature of the contact and the fact that the complainant is here requesting, she came here specifically to request that the no contact order be lifted. I understand, Your Honor, it is what it is. We are the court, prosecutor, court staff, witness what they saw. However, incarceration, I feel, does not suit the alleged crime. I feel it's, I can understand the court perhaps denying the motion, but incarceration at this time does not seems
yeah, but if somebody's not listening to the court, why would I just slap them on the hand and tell them to go forth and sin no more? I mean, this isn't a hard one to understand.
No, certainly not, Your Honor. I suppose we are asking for clemency at this time.
I did get into the meat and potatoes of the report, but for the court's information, the officers observed that the bed mattress was flipped over in the bedroom when they arrived, and they observed broken glass on the bedroom floor, and the information provided by the victim, to the police officers at that time was from old Christmas ornaments that the defendant had been destroyed. It says that Denison had destroyed, but I think that may be a typo in the report.
Say that part to me again.
So the report reads, that there was broken glass came from old Christmas ornaments that Dennison had destroyed. I think that may be a typo and may need to say Isom. I think that just may be a typo, but that is what the report reads. And I want to be candorous to the court.
In that last case, one of the other issues here is, and Mr. Burdell, maybe you can explain to me, why would your client be under a different assumption of what no contact meant if he's been through this before?
I think, I mean, that he did explain himself that it was ignorance and,
Well, it can't be ignorance. I mean, it almost points to a flagrant violation because he's been through the process before.
Judge.
Go ahead.
Judge, I believe, I think Mr. Isom has explained himself, and that at this time I have nothing to add on as to what his motivation or what was inside his mind at the time.
On the last case, did he abide by the no contact on the last case? Or did we have problems?
So I wasn't involved in the last case, but Mr. Isom is assuring me that he did on the last case. That he was never violated on the last case, which again was dismissed. It's not a case he was not convicted for. It was not the case he was convicted on.
I understand that. I guess I'm trying to figure out whether or not, I mean, because the issue for me is whether or not he's going to follow the court's order. And the court ordered something, and it wasn't that long ago that we ordered it, on the 25th of November. And
well, Your Honor, I have my limited contact with Mr. Isom in our conversations. I am confident that he will abide by the orders. He is, he has assured me that there have been no contact prior to this, and he has abided by the no contact order. Outside of the court, there have been no calls, there's been no contact. He immediately moved in with his brother. He's 60 years old and then with his brother into an apartment, Judge. And I am confident, no matter what the court orders today, he will abide by the no contact order. Granted, this is a fairly new case. However, he has been, other than the indiscretion this morning, he has been compliant with the court's orders on everything.
I need that. Is he working?
What do you?
Remodeling.
He does, he's remodeling as a contractor. Are you a self-employed or do you work for somebody? He's self-employed. And do you have any big jobs coming up?
Slondi, was there something else you wanted to say?
To give additional context to the question the court had about the last time, I counted, and from December 26th to the request on January 8th, the defendant would have been on a no contact order for 13 days. And he would have been out of custody. So there's not a lot of time in there for us to know. And now we're here, and it's been, not very long at all, 7 days since the incident. The arraignment, rather, excuse me. So, and if people again would contend that this is a bond question.
Did you provide the address that you're staying at to the court? Why not? You know what?
I don't know. My brother to get it. I've been staying with him before. It was house is nowhere near there. This apartment is on 94.
So, sir,
Yes, sir.
your release order indicates, reading from paragraph 10, you're not to go to the 5229 West Michigan Avenue. I'll leave out the lot number, except with a civil standby with the police. Then it further reads, if this is your home address, which it is, you must find another place to live and notify court of your new address within 24 hours of your release from jail by contacting, and then we put the court's number in. What?
Did not read that, I'm sorry.
Karen, he would be able to provide his brother's address today if given a few moments to make the call and just to confirm. No, this is the first pre-trial. Just for the.
I understand it's the first pretrial, but I mean, I've got at least 2 violations before we've had the first pretrial. I mean, what is it? He doesn't think he has to follow the rule?
No, Judge, that's certainly not it. I mean, this is, understand with the holidays that just occurred. It is a lot going on for a civilian. So, but I've assured him now that he has counsel. Like I said, I was just very recently appointed. I will make sure to give him extra attention to guide him to make sure that he is in compliance going forward.
When were you released from jail?
One day. Or
The 25th. And when did you go to your brother's house? What?
I went there then.
And so on the 26th and 27th, you didn't think you had to notify the court?
I didn't understand that part. I didn't read it.
Well, you better, I'll tell you what, I'll pass the matter. You just got to go find that address.
Thank you, Judge.
Finally, our last case takes us to Judge Simpson, presiding over Benelli Cruz, a woman facing charges for aiding a felon in covering their tracks.
Court does call the case the people versus Benelli Cruz.
Andrew Childers appearing on behalf of the people, Your Honor.
Good morning, Your Honor. Marcia Creech on behalf of Ms. Cruz. Ms. Cruz, can you please state your name?
Benelli Cruz.
Your Honor, it's my understanding that Ms. Cruz will be waiving her right to examine surveillance 2, which is accessory after the fact to a felony. People will be dismissing at this time on that basis of the waiver as we come to.
That's a correct statement, Your Honor.
And Ms. Cruz, is that correct?
Yes.
All right. Have you had an adequate opportunity to speak with your counsel regarding waiver of the preliminary examination?
Yes.
And you understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Correct.
All right. You understand you will not have that hearing, which is set for today, and you'll proceed to circuit court for further resolution.
You have to say.
Do you
yes.
understand that?
Yes, you have to say yes or no.
If I said something you don't understand, just tell me. You understand you're not going to have a preliminary examination.
Right, correct. Yes.
Okay. And you understand also that you're waiving your right to have that preliminary examination on actually both charges, but you're waiving up to circuit court or going to circuit court on the charge of accessory after the fact to a felony.
Yes.
A 5-year offense. You understand that?
Yes.
Did you have any questions about this waiver?
No.
No? Okay. People also waive.
That's right.
Preliminary examination having been waived, defendant is bound over on count 2. Richard.
Your Honor, we have received the information, waive its formal reading, and my client will stand mute.
Defendant having waived formal reading, standing mute to count 2. Count 1 is dismissed. Pretrial in this matter will be set for
December 19th at 1:30 before Judge Slate Thursday.
December 19th, 2024, 1:30. Slade Thursday.
Thank you, Your Honor.
Thank you. 1 second. Set.
Yes.
It's gonna be. If we hold his, it goes up, there's gonna be a different thing.
Yeah, it's gonna be.
Oh, it's gonna be way up. Okay. All right, just so that you're aware,
Yeah,
you,
that's
okay,
fine.
okay.
Yeah.
All right, very good.
Thank you, Your Honor.
Bond will continue. Thank you.
Wait.